so great to be welcoming in to now Daniel R. Streett, attorney, legal analyst, and author at Daniel R. Street's Fake News Exposed. Daniel, thanks for coming on.
Thank you for having me. Glad to be here.
So let's talk about it. SCOTUS had some very pointed questions surrounding the idea of kicking a person off of the ballot for something they haven't been convicted for, or kicking them off of the ballot, period. What did you make of what we saw at the Supreme Court?
Well, I have to tell you, the oral argument on the Colorado disqualification case went far worse for the parties defending the Colorado Supreme Court than I think anyone anticipated. Certainly worse than I anticipated. They were peppered with tough questions by every justice on the court that said a word. Even Justice Jackson, Justice Kagan, both of those justices who I believe the the parties defending the Colorado Supreme Court were expecting some softballs from those justices. Well, they didn't get any. And so it just really could not have gone worse for the Colorado Supreme Court's decision than possible.
So I found it interesting that it wasn't just the so-called conservative justices. It was those who are considered to be firmly on the left side of the aisle who asked some of the most common sense questions surrounding, just basically using one person in a jurisdiction who is not elected. This is just an individual, and that person decides based on their feelings that someone shouldn't be on the ballot and then executes on that. It was interesting to hear the way that they framed what they were talking about. It sounded so common sense and like regular man.
Yeah, I thought one of the pivotal moments of the oral argument was from Justice Kagan. When Justice Kagan challenged, I believe it was Jason Murray, um, why should the state of Colorado have the power to make this decision for everybody? And of course, Murray tried to deflect, and then Justice Kagan came back with, the state of Maine has followed the Colorado Supreme Court decision. So that's an issue that deals with what is known as collateral estoppel. But for to get those types of tough, poignant questions from Justice Kagan, I think that the people defending the Colorado Supreme Court's decision weren't expecting that, and frankly, I wasn't expecting that. And I think it just indicates to the American public that the Supreme Court is going to turn this around. I wrote in my Substack that the Colorado Supreme Court has a come up it's coming, and they do. And I think it's going to be even more unanimous. It might be unanimous or 8-1, but it's going to be a emphatic statement from the court that this was wrong.
So let's talk about this for a second. You talked about estoppel of the court. To tell us what that is specifically, because this is our opportunity to learn a bit more about what you are so well versed in, which is the law, as it pertains to this issue.
Well, thank you. Well, there's several versions of what is known as collateral estoppel, but what will happen in this particular context is just like the Secretary of State in Maine did. She followed the Colorado Supreme Court's decision essentially. Now, the Secretary of State in Maine is not even an elected official; she's a bureaucrat. And she says, "Hey, look, we don't have to relitigate all this. The state of Colorado already found X, Y, or Z." So collateral estoppel in this context is just a legal principle that, and really in this context, is being stretched beyond what it's supposed to be used for. To say that the same parties don't have to litigate or shouldn't have to litigate the same questions repeatedly or more than once. And of course, the difference here is there's not similarity of parties, so they're really getting beyond that. So it's a stretch to use that particular doctrine in this case, but it's going to be used if the United States Supreme Court had not intervened here, then Democrats and leftists all around the country were going to rely on the Colorado Supreme Court's ruling to disqualify President Trump.
So that I think that's the most infuriating part for Americans is if you live in Michigan and you plan to vote for Trump and you hear that he won't even be on the ballot, but it's not because you as a Michigan voter actually weighed in on that. You are just kind of like literally following another state, a state you've literally chosen not to live in, because if you choose to live in Colorado, you are essentially choosing not to live in Michigan or Maine or all of the other states. You've chosen not to live there. So the decisions made in those states, you are actually guaranteed a federal government by the Constitution. Each state is guaranteed that. So you're guaranteed that your state has its own constitution and you will live under that as long as it doesn't directly oppose the federal government. So federalism is at issue here in addition to what you just described.
Yeah, well, and actually, what we're talking about here is really tied into another issue that the Supreme Court was very critical of, and that's what's called self-execution. The the real one of the real questions before the court is Article 3 of the 14th Amendment, which is what was being used to disqualify President Trump, is that something that an individual voter can file a challenge based on, or does there have to be some sort of authorizing enforcement statute? And the Colorado Supreme Court ruled that Article 3 of the 14th Amendment was self executing, which means any voter could file a challenge against any person under it. That is not what the law has been. And there was an enforcement statute passed in 1870 that laid out by Congress how these challenges, and of course at that time the challenges were against former Confederates who had fought in the Civil War against the United States. So but the problem is that enforcement statute was repealed in 1948. So there's really no mechanism in federal law to allow for a challenge like this to even be filed. That's why the Colorado Supreme Court had to resort to self execution. That's another grounds that the Supreme Court of the United States is going to reverse the decision on.
So, Daniel, as we close out here, talk to me about what's next. When will they make a decision? When will we know what they've decided about this particular case?
Well, we don't know for sure about that, but I can tell you that when President Trump's legal team filed the writ application with the Supreme Court granted that writ within 48 hours, which is the fastest I've ever seen them grant any writ. They set the argument, they set a very aggressive briefing schedule, and the argument was on February 8th. So uh, I expect a ruling within 30 days of February 8th. So I anticipate probably by the end of this month or maybe the first week of March, we will know that the Supreme Court's thoughts about all of this. And it's my belief that the United States Supreme Court is going to put an end to all of this nonsense that Democrats and never Trumpers have been waging all over the country to try to get President Trump off the ballot. That's going to be over with. They'll have to focus on some of their other illegitimate lawfare.
I'm loving it. Okay. We'll have you back to talk more once the ruling is actually issued. We're so grateful for your expertise today. Thank you, Daniel R. Streett. We appreciate your work.
Thank you. Thank you for having me.
All right. Good to see you. And we have more now coming up next. Stay right there.